Welcome to Privacy Unpacked. I'm Ruth Boardman, co-head of Bird & Bird's International Data Practice. Pseudonymisation, anonymisation, and other privacy-enhancing techniques is one of my favourite topics. Today, we're going to discuss new draft guidelines on pseudonymisation, recently published by the European Data Protection Board. We're also going to discuss a recent Advocate General's opinion in the SRB case. Now, when I have a tricky issue, I need a smart person to run it past. I frequently call Simon Assion, one of our German partners. Pseudonymisation is also one of Simon's favourite topics, so I'm super excited that I get to host this podcast with Simon and to ask him all my difficult questions on the topic.
And likewise, I'm very excited about that as well, Ruth. I think we both enjoy picking each other's brain very much, and that podcast now maybe shares that experience with our listeners.
So the concept of an author writing under a pseudonym is something that we're all familiar with, but that's not quite the way that GDPR uses the term pseudonymization. So let's start at the beginning. And Simon, maybe you can explain the GDPR concept of pseudonymization to us.
Yeah, indeed, because non-data protection professionals will confuse that pseudonymization concept known from data protection law with the use of a pseudonym in literature publishing. But when it comes to data protection, pseudonymization is a privacy enhancing technique, a PET, that generally improves privacy aspects of the processing, so makes it more friendly to data protection interests of the data subjects. And it does that by weakening the relationship between the data and the data subjects, meaning the natural persons to which the data relates to. So this relation is not cut, it's not completely removed, but it's weakened.
So you've explained that pseudonymization weakens the tie between data and data subjects, but the tie is still there. Can you give us an example to make that clearer?
A simple example is much like pseudonymization in the context of literature. It removes the direct identifiers from datasets and exchanges those identifiers with indirect identifiers. So, for example, the name is removed, like in case of publishing a book under a pseudonym, but in case of data processing, it's usually not exchanged with another name, it's usually exchanged with a number or with a numeric code. So if that code is completely random, if it's a random number, then the dataset now is anonymized. But if somebody keeps a table that connects the numbers to the names, meaning that you can translate back and forth, you can tell which number is what name and which name is what number, then the data is not anonymized, it's pseudonymized. And that table then is called a mapping table. Another example of pseudonymization is encrypting the data, because encryption also has the effect that if you don't have the decryption key, then you cannot directly establish the relationship between the data and the data subjects. So in short, pseudonymization means that the data still has some connection to the person who it can be attributed to, but that connection is hard to get to. So that's pseudonymization in a nutshell. But I think we wouldn't have that podcast session here if things were so easy. So a lot of issues are unclear, especially what the difference between pseudonymization and anonymization is. So for example, if now we apply that concept that I just explained of weakening the relationship, for example, by exchanging direct identifiers to indirect identifiers. If we apply that concept to a situation where we have two persons involved, let's say Adam and Berta, and now Adam has the means to identify the people. So Adam has the mapping table, but Berta hasn't. And now Adam gives the pseudonymized data set to Berta, but not the mapping table. Now, what does that mean? Is the data personal for Adam? Is it personal data for Berta? And what about any third party? What if neither Adam nor Berta have the mapping table, but it's somewhere else? A third party has it. What does that mean for Adam and Berta? That's one of the most crucial questions that data protection scholars have been pondering for decades. I would say that question was invented directly after the invention of data protection law, and it's still unclear.
So the example you gave, Simon, of Adam giving data to Berta is central to the SRB case. In that case, an EU institution, the Single Resolution Board, commissioned a survey. The SRB had the identities of the people who participated in the survey and their opinions. It wanted to give Deloitte a version of the survey data where Deloitte didn't know who had said what. So SRB replaced the identities with unique codes. The SRB knew which individual related to which code, but Deloitte didn't do. And this was the only way to identify the individuals. The question that the CJUU will have to answer is whether the information is anonymous in Deloitte's hands, or whether it's still personal because the SRB maintains the lookup table. The SRB and the European Commission think that the data is anonymous because Deloitte, so Berta in Simon's example, couldn't work out who the individuals are. However, the European Data Protection Board and the EDPS think that the data is still personal because the SRB has kept that lookup table. So what did the Advocate General say? He said that you have to look at this from Deloitte's perspective. So going back to your example, Simon, of Adam sharing data with Berta, you have to look at it from Berta's perspective. The key question, as far as the Advocate General was concerned, is whether it's reasonably likely that Deloitte can identify the individuals, not whether the SRB can still do so. Now, this question is really important, not just because it's a fundamental starting point for whether or not GDPR applies, but also because it occurs frequently in real life. To take one example, if you have data that you want to use for health research, it's increasingly common to make use of a trusted research environment, where the parties with the data de-identify it, they keep the key, but they put the data into a trusted research environment where researchers who never have access to the key can access the data. So this is a real-life question that needs to be answered. Now, to my mind, it's implicit from the guidelines that the EDPB has issued that they see this differently to the Advocate General. What do you think, Simon?
It is my impression. It's sort of funny and tragic at the same time, though, that the EDPB managed to publish fully fledged draft guidelines, long and complex, without saying a word about the differences between pseudonymous and anonymized data. I mean, that's the most crucial question. And as you said, it's so important for data protection in practice. You mentioned trusted research environments. I could, for example, mention data sharing obligations or freely sharing data under the Data Act. There's provisions in the Data Act that say that different rules apply to personal and to non-personal data. So what does that mean? If it's Schrodinger's data, where the personal relation depends on the angle that you take when you look at the data, from which position you look at. Depending on the position, if you look from Adam or Berta, the same data set can be personal or non-personal. What does that mean under the Data Act? And that's just one of so many instances where I encounter that question in practice. And I think everybody within Bird meets that question on a weekly basis, probably. I mean, every data protection lawyer, of course. So cycling back to the pseudonymization guidelines, it's quite astonishing, but on the other hand, understandable that they completely walk around that topic. And that's, quite difficult if it's actually the elephant in the room, basically. Now, we do know, though, for example, through the submissions of the EDPS and the EDPB in the SRB case that we just mentioned, that in practice, the data protection authorities take the view that pseudonymous data is data that is still personal data, irrespective in whose hands it is. So they disagree with the view of the Advocate General, and they say even for Berta / for Deloitte, in that case, the data is still personal data. It does not matter whether Deloitte was able to attribute the data to natural persons. The mere fact that the SRB could do it already had the effect that the data was personal data. That's the view of the data subjects, but you can see, Advocate General and the competent data protection authorities disagreeing on that fundamental question. I mean, that looks like worlds colliding there. And I'm really looking forward to the decision of the Court of Justice at the end of their procedure.
I know from interacting with you before this podcast, Simon, that you found the Advocate General's opinion disconcerting, hard to fathom on this point. Whereas I read it on this point and thought, yes, that all seems very familiar. And that's because there's very long-standing UK case law on this specific issue, which very much takes the same approach as that taken by the Advocate General. And interestingly, the cases that we have in this area were actually triggered by freedom of information law. And that's because when a public authority receives a freedom of information request, it has to consider if it would be disclosing personal data as part of the information that's disclosed. And in these cases, the Supreme Court has held that if the recipient can't identify individuals, for example, because techniques such as perturbation have been applied to the data, then that's determinative. The fact that the public authority could still work out who the individuals are and could still identify them doesn't matter. So we've got cases which are very close to the position on this point expressed by the Advocate General. We also have draft guidance, not from EDPB, but from ICO. However, unfortunately, progress on that has been somewhat stalled. So the guidance was launched in February 2022, but it was paused while changes to UK data protection law go through Parliament. So the case felt quite reassuring to UK eyes.
Yeah, and to some extent, I must say it's also reassuring to me because I'm not a fan of the view that data in almost all situations has to be personal, even if the actual risk to the data subject is super minimal. Because if you take that extensive view of the EDPS and the EDPB, as a result, quite many very beneficial data processing activities, like, for example, scientific research, become much more difficult to manage and in some cases not even possible because the GDPR doesn't allow an actual legal basis, for example. So I really hope to get some relief from the European Court of Justice there. Now, a question for you. The case law that you just described is a good entry point to the concept of the pseudonymization domain. That's a concept that basically has been invented, at last, as far as I know, in the EDPB guidelines on pseudonymization. So there, the EDPB uses the words pseudonymization domain, and by that, I think they mean that data can be pseudonymized only in a certain domain, whereas it's not pseudonymized outside of that domain. That seems to be an entirely new point, at least to me. Ruth, can you talk us through that?
Yes, exactly that. So the EDPB recognises that controllers often use pseudonymization to stop a particular person or group of people being able to have access to the lookup table or the data that would allow full identification. So in the example I gave earlier of freedom of information cases, then this is the person making the FOIA request. And EDPB refers to this concept as the pseudonymization domain. So to give another example, perhaps the classic example, that would be a clinical trial where key coding is used so that the sponsor doesn't know the patient's identity, save in limited circumstances. So in the case of a clinical trial, the pseudonymization domain would extend to the sponsor, but the treating institution and the investigator would be outside the pseudonymization domain because they have access to the fully identified patient data. And the reason that EDPB introduces this concept is that it says that when you want to decide what measures are necessary for pseudonymization to be effective, then you have to consider the nature of the pseudonymization domain. So if this is purely internal recipients, then you may need lighter touch measures by comparison with disclosure to the world at large, where the pseudonymization domain is enormous, and therefore you have to have stronger controls in place. If we maybe change topics slightly and maybe move away from looking at what pseudonymization means to looking at where it can benefit people. And I know, Simon, that when you first read the guidelines, this was one of the things that you found particularly interesting, the idea that pseudonymization can actually be a tool for compliance. Can you share how that might work?
Yeah, I really like the pseudonymization guidelines overall because what they are is they try to be a part of the solution and not of the problem, meaning that the authors of those guidelines obviously try to enable solutions to enable beneficial and helpful data processing operations. So they want to avoid situations where the GDPR basically is a showstopper or a roadblock, and want to explain how to work around issues that one can encounter when trying to, bringing data protection activities in line with the GDPR. And pseudonymization is one of those solutions. You can call it like a hack or a workaround that data protection practitioners like you and me can use to unlock situations where previously you thought, okay, we can't do it, the GDPR prohibits it. However, now if you apply pseudonymization, that sort of unlocks the problem and you can overcome it. So the guidelines explain that in different relations or in relation to different legal issues. And I think the most important part where they explain it is in relation to the legal basis of legitimate interests, or it's also sometimes called the balancing test, 6.1 letter F GDPR. And there, the EDPB goes on record by saying that pseudonymization can help organizations to win that balancing test, meaning that their legitimate interests in the processing are stronger than the interests that speak against that processing. So that balancing test can be won on the basis of pseudonymized data, and it couldn't be won if the pseudonymization wasn't applied. So in practice, that means a lot, for example, business models around Internet of Things or clinical or medical research, for example, or for AI training. AI training is, I think, one of the situations where pseudonymization is key to make things possible.
I guess we'll see on that one. So we've looked at what pseudonymization means, and we've also looked at the benefits it can bring. The other part of the guidelines that we've not yet looked at is what the technical requirements are for pseudonymization to be effective. Now, this part of the guidelines is actually really clear. It's accessible and it's an easy read. And it's not always easy to translate technical concepts into easily accessible language. So well done to the person who drafted this part of the guidelines. I think they've done a really good job. So I was going to share 4 key points from the draft guidelines here. So the first one, the first rule, if you like, pseudonymized data must never contain direct identifiers. That's the first suggested technical point. The second, you have to make sure that you don't have other unique fields or combinations of unique fields, so that never mind the coding you've applied, you have to make sure that you can't otherwise identify the individual from the data. Thirdly, there is guidance on choosing effective cryptographic measures and on the technical and organizational measures needed to secure access to the systems performing the pseudonymization. And then fourthly, this takes us back to the pseudonymization domain. If you're disclosing data to a defined group, like my trusted research environment, then the guidelines say that contractual measures are a requirement, but that they aren't sufficient by themselves. You would need more. So, for example, technical checks and audit. And for anybody who wants the full download on the technical standards or measures that EDPB says are important, then there's a great 1-page summary of the technical guidance in the draft guidelines.
Yeah, absolutely. I can only second that and say a big thank you to the person who drafted that part. It's very practical advice. The only thing that I find a bit curious is that, if we would ask the Advocate General, he would say that's not pseudonymization guidelines, it's actually anonymization guidelines. At least that was my thought. Is that actually pseudonymization, or isn't even that removing the full relationship to the data subjects if the measures are so effective? But nonetheless, obviously, that remains a moving target. We don't want to stretch that podcast for too long, but of course, there would be more and more things that we could ramble on. But maybe that's a good opportunity to say that if you have any questions for Ruth or myself or anybody else from the Bird and Bird data protection team, reach out. You can find us online on social media. Our emails are available. Please just get in touch. And otherwise, if you have any ideas for new podcast episodes, also let us know. In any case, we look forward for you to joining us next time.